Good morning, everyone. And we have one case for oral argument today, and that's State versus Wells. And both sides will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes for a rebuttal. I know counsel are very familiar with our procedures, obviously, since you argue in front of us often. But I just want to make sure, since we are being broadcast and videocast on YouTube and all over the place, that we make sure that we don't use the names of victims or children, and just make sure we follow those rules. So we're ready to begin if you are. And Ms. Bremke, did you want to save some time?
I'll reserve 5 minutes, Your Honor.
Okay, you may proceed.
Thank you. Giovanna Bremke on behalf of Miss Danielle Wells. Miss Wells pled to, and I'm going to go through procedurally because it is important in this case. She pled to several felony counts, ranging from felonies second degree to felonies of the fifth degree, and a misdemeanor as well. She pled in December of 2016 before Judge Arredondo, who's no longer a judge, and that's important because there was an agreement with the prior judge, Judge Arredondo, that Miss Wells receive a community control sentence, and if she violated, she would receive a 6-year sentence upon violation. In January of 2017, only less than a month later, or a little bit more than a month later, but about a month, Judge Cook is then in office, and he also agreed to the community control sanction. And this is when Ms. Wells went for sentencing. So she was pled with one judge, sentenced with another. And at that time, Judge Cook indicated that he didn't agree to the 6-year agreement, that he would agree to 8 years with concurrent terms for the various counts. She, as you may know, spoiler alert, she later violates community control and received a sentence of 12 years that includes consecutive terms. We also agree, for once, the state and I agree on some things here. So there's 4 assignments of error, and the state concedes that in their brief, and they'll correct me if I'm wrong, but their brief indicates that they concede that any term imposed over 8 years was an error. So that particularly relates to assignment of error 1 and 3. So I'm going to focus my argument on assignment of error 2, which is the part that we do disagree on. So again, Ms. Wells sentenced to 12 years. We both agree, that it shouldn't have been over 8. And my argument is that it should have actually only been 36 months. So, and the reason for that is essentially, as this court's aware, the Supreme Court came down with a decision in 2004, State v. Brooks, that says that a trial court has to sentence an offender to, when sentencing an offender to community control, has to reserve a stated prison term that is specific. And if it's not imposed, then it can't be imposed later. So in this entry, there was a range of sentences. So, and also on the record, it's 2 parts here. On the record, the judge never addresses count 1. In the entry, there's a range. Now later, about 18 months later, after the probation violation hearing proceedings start, then there was a non-protunct, which the state argues, brings up. My argument to that is the non-protunct can only address what was done on the record, can only correct what was done on the record. Count 1 was never addressed on the record. So what was addressed in
Counsel?
this? Yes, go
So
ahead.
just so I'm clear in your argument, count one was never addressed on the record initially by Judge Arredondo or actually at the time of sentencing by Judge Cook.
I'm not disputing that there was a plea. So Judge Arredondo did address, is my understanding, she did address it. And I'm just saying there was never a specific sentencing term imposed on the record at sentencing.
By Judge Cook.
Yes.
So you're saying Judge Cook, when we look at the transcript of the sentencing, did not impose 8 years. Is that correct?
Correct.
Okay.
So, and it's transcript page 22 to 23, and I quote that in my brief, but he specifically goes through counts 2, 4, 7, and 8, and says, you know, these are the specific terms. So count 2 is 1 year, count 4, 36 months, count 7, 18 months, count 8 is 6 months. So it's a misdemeanor. And then he says, I'm going to run all those concurrent. So my argument is the most that can be given is the 36 months, because that is, you know, there was an agreement there. The only thing on the record is those counts, the specific terms for those counts, and the 36 months was the highest, and then he agreed to run them concurrent.
So and that's the argument, excuse me, that's the argument without the non-pro-tunc, obviously.
I would even argue with the non-pro-tunc, because the non-pro-tunc can only correct what was said on the record, and it was not said on the record. And it's interesting about this non-pro-tunc is it comes 18 months later after there's probation violation hearings have already begun, and the court has further acknowledged in the probation violation hearings that it didn't get sentenced on count, that there was no sentence on count 1. So in reviewing with Ms. Wells, hey, you violated probation, you know, and this is what I can impose, there's an acknowledgement that, oh wait, count 1 didn't get sentenced on. So, and that's, those transcripts are also outlined in my brief. And what the state is arguing in their brief is that that doesn't go to the actual sentence, which I agree, that's a subsequent sentence, but it's further proof that that wasn't said, that there was no sentence on count 1, if that makes sense.
So you're saying there's no sentence at all on count 1. So wouldn't that have been a final appealable order issue?
So,
sorry
no.
to throw another monkey wrench in.
I thought that may be addressed, but no. I think that it's more of a Brooks issue where there wasn't anything said on the record, but there was in the entry this range, and because of the range, Brooks, is my understanding, wasn't a final appealable order issue. It was, if you don't put that specific term in your entry, then it can't later be imposed. Now, the non-pro-tunc, again, I would still argue you can't edit that non-pro-tunc to have a specific term that wasn't stated on the record.
Thank you.
I reserve the rest of my time.
Thank you. The state?
Morning, Your Honors. Lindsay Poprocki on behalf of Appellee, the state of Ohio. As the appellant indicated, the state did concede the assignment of error 1, but at the outset, the state submits that its concession must be considered in its proper context and in light of acknowledgements made by Wells in her own merit brief. The state recognizes that when a trial court sentences an offender to community control sanctions, as it did here, it must, at the time of sentencing, notify the offender of the specific prison term that may be imposed for a violation of community control. In turn, the prison term imposed upon a violation shall not exceed the prison term specified in the notice provided at the sentencing hearing. The crux of Wells' first assigned error is that the trial court erred in imposing a prison term of 12 years upon her violation when those 12 years were in excess of the stated 8-year prison term reserved at sentencing. The state agreed that Wells' argument had merit, but only to the extent that the trial court expressly indicated that the stated reserved term of prison was 8 years, and then went on to impose a 12-year prison sentence upon Wells. The state would submit that the court noted this court has noted that the specific prison term identified at the sentencing hearing sets a ceiling on the potential prison term. At her sentencing hearing, the trial court expressly advised Wells that if she violated the terms of her community control sentence sanction, it would impose an 8-year stated prison term. That is at page 22 and 23 of the transcript. The state would submit that based on this notification, the trial court had the discretion to impose a full 8 years upon Wells on her subsequent violation, but the state acknowledges it did not have discretion to impose more than the stated 8-year prison term as it did. Wells expressly acknowledged and quoted in her brief in bold print the trial court's reservation of an 8-year prison term in her merit brief while arguing her first assigned error. She then goes on to argue in her second assignment of error, however, that the trial court was actually limited to imposing a prison term of 36 months upon a violation of her conditions of community control. Upon reviewing Wells' 2 assignments of error in light of one another and the trial court's notification at sentencing, in its appropriate context, the state submits that the trial court properly reserved an 8-year prison term. In her second assignment of error, Wells shifts her focus from the specific notification that she received at her original sentencing hearing to the trial court's failure to mention the specific 8-year reserve term at a subsequent merits hearing to argue that as a consequence, she could only be sentenced to 36 months in prison. However, a trial court need not repeat the prison term notification at every intervening hearing in order to preserve its ability to sentence an offender to prison for violating community control, as long as that notice was given at the initial sentencing hearing. That's an Ohio Supreme Court decision out of 2020. I believe it's Howard. Here, the notification of the specific 8-year stated prison term was provided by the trial court on the record at Wells' sentencing hearing, again at page 22 and 23 of the transcript. After the trial court notified Wells that, quote, I am going to make it an 8-year stated prison term, the trial court then notified Wells that the balance, quote, of the prison terms on counts 2, 4, 7, and 8 would run concurrent to one another in the event of a violation, and specifically outlined the length of the stated terms on each count. Notably, in arguing her second assignment of error and in her reply brief, Wells only quotes a portion of the trial court's notification and omits relevant advisements regarding the stated 8-year prison term. This notification of the 8 years, however, was critical, as the trial court is not required to repeatedly notify Wells of the potential prison term at subsequent hearings once it made that advisement at the sentencing hearing. In conclusion, because the prison term imposed upon Wells following the revocation of her community control sanction did exceed the prison term specified in the notice provided to her at her original sentencing hearing and did include consecutive terms, the state of Ohio does request that the case be remanded for resentencing consistent with the trial court's notification.
Thank you.
Thank you.
And appellant has the full 5 minutes.
Thank you, Your Honors. And I wanted to address a few things because the state brings up some good points. So in my first, I want to make it clear that I'm sort of arguing in alternatives here. So in my first assignment of error, I'm saying, yes, he should have imposed the 8 years. But further than that, in the second assignment of error, that it should be actually not any more than the 36 months because of the Brooks issue. So I wanted just to make that clear, that was sort of arguing in alternative. Another thing I wanted to clarify is that the state says that in the first assignment of error, there was, point about the 8 years. There is discussion about if she violates, she will receive 8 years, but there's never a specific prison term stated for count 1. So it's very clear these other counts have specific terms stated, but count 1 does not. So while there's a general discussion about if there's a violation, it would not be clear to the reasonable defendant that the count 1 would have this specific stated prison term. So again, I would
Counsel, just on that last statement, if the language was, if you violate, you will receive 8 years, I do not understand how that's not clear to a reasonable or even unreasonable defendant.
Yeah, so it's interesting because it's not clear. I don't know that it's clear to all of us sitting here, and we're certainly not the reasonable defendant. I think we have a little bit more knowledge. But if you add up the other terms, and I know he's saying that they run concurrent, but it's confusing. If you add up the other terms, they come close to that the other term that he's talking about, the 8 years. So I don't know that a reasonable defendant would think, yes, on count 1, I will receive 8 years. And I think that's exactly what the Brooks case addresses, that if it's not stated in the sentencing entry and it's not on the record, then the reasonable defendant wouldn't have an idea, wouldn't be able to conclude that that's what their sentence is. So the other counts are very clear. And in the transcript, it's specific. Count 2, this sentence. Count 4, this sentence. But count 1, there's not a specific prison term stated. So,
excuse me, what impact does State versus Howard, the 2020 Supreme Court decision, have on your argument?
Is that Your Honor, I'm not entirely familiar with that enough to say how that would affect this case, unfortunately.
And I'm sorry, you broke up, so I could not hear your response.
I'm not familiar with that case enough that I would be able to comment on that.
All right, thank you.
But again, I would agree with the state that that the case needs to be remanded. I believe we agree that the sentence shouldn't have been more than 8 years. But again, I would argue that it shouldn't have been more than 36 months because of these various issues with the sentencing entry and the term not being on the record. Thank you.
Thank you. Thank you both for your arguments to the court. Thank you for appearing via Zoom this morning. And we will take the matter under advisement, and we will issue a written opinion that will be sent to both sides, as well as obviously we release it online with the Supreme Court and our website. The next